as our outline. I'm Steve Hardwick. I'm at the State Public Defender. I'm in the adult felony department, but a lot of my case, I've done a lot of work with kids who've been bound over and sentenced to lifelong times in prison. This is Tim Hackett. He's in our juvenile department.
Yeah, I do juvenile appeals in the juvenile department. Most of my clients as well have been bound over, tried as adults, and are in the adult population serving extreme sentences. Yeah, we had a PowerPoint for everybody, but weren't able to get it to work. So I'm going to pass out some handouts here, though, that kind of guides what we're going to be talking about, some statistics and whatnot. So you guys could pass these around.
He's going to talk about some statistics, how things are going, and then I'm going to come back and give you just the lay of the land and where things are legally and what the rules are for when courts end up sending kids to prison for life. You're up to the...
All right. So yeah, like Steve said, I think we'll just start out kind of with an overview of juvenile life without parole. I'll give you guys some kind of eye-opening statistics, and then Steve will talk a little bit about the black letter law, kind of the rules of juvenile life without parole, when it can and can't be imposed, based on a couple of Supreme Court decisions over the last 10 years or so. And then I wanted to share with you guys some of the things that the Ohio Public Defender's Office is doing to assist on the litigation side, the legislation side, and then also with connecting to the last topic, parole assistance as well. And then I do have some other resources for you that there was a link to it, but if you want those resources, it's for the campaign of the fair sentencing of youth. There's a, Getting Involved Resources Network, and then a family support network too. It's a national organization. We can talk afterwards, and I could give you the information about that. And then we'll finish with, just question and answer as well. So starting at the beginning, just a little bit of background. This really goes back to the 90s. 1990s, the myth of the teenage super predator. That's what was going on in the 90s. And so in response to this myth, this rise in juvenile crime, it led most states to enact these tough on crime policies, which made it possible, one, to try kids as adults at younger and younger ages. But with that came, two, the ability to then sentence kids as adults, too. And so the mix between those two things really led to just these extreme sentencing for juveniles throughout the country. And so some relevant statistics on that: the U.S. now is the only country in the world who sentences kids to life without parole. To date, 2,570 kids have been sentenced to jail WAP. In the U.S., we'll spend, and you guys were talking about the money last session as well, the U.S. will spend over $4 billion to incarcerate these 2,570 kids throughout their lives. So $4 billion just to keep these kids incarcerated for things that they committed as they were juveniles. 11 of those kids are in Ohio. So Ohio has 11 JL-WAP kids. The handout says 9. That's a little outdated. Unfortunately, there's 2 more. There's 11 right now. And shockingly, I didn't know this. This kind of made my eyes pop out of my head. Only 5 states are responsible for 2/3 of the JL-WAP sentences. So of that 2,570 number, only 5 states imposed all of that. And those states were California, Florida, Louisiana, Michigan, and Pennsylvania. Again, like I said, 11 came from Ohio, unfortunately. And significantly and importantly, African American kids are serving JO-WAP sentences at a rate that is 10 times per capita more than white children. So there's absolutely, and it's no surprise, but there's absolutely, a disproportionate impact of these tough on crime policies. That's something that we all know, but I think that number is staggering, 10 times more than white kids. So, over the last 30 years though, since the 90s, adolescent brain science comes into this, and adolescent brain science has made significant developments and advancement in terms of understanding the juvenile brain and explaining, juvenile brain development and how that relates to juvenile conduct and behavior. So a lot of the things that you see, the recklessness, the inability to foresee consequences, the decision making, that is all a product of brain development. And importantly, the Supreme Court has heeded that advice. They've listened to the science. And so in a series of 4 decisions, there's a 5th one pending right now, which Steve's going to talk about those decisions. The Supreme Court listened to the science and has kind of made a sea change, scaling back, first starting with death penalty for juveniles and then moving to life without parole, scaling back the ability of states to impose these sentences. And so, yeah. Because of this new understanding and based on the Supreme Court decisions, a number of states have banned JLWOP sentences already, or they're just simply not using them. To date, there are 28 states who have either banned or not using JLWOP. Unfortunately, Ohio is not one of them. We're moving in that direction, I think slowly but surely. There's a lot of work to be done, no doubt. But, last legislative term, there was a bill pending. Unfortunately, it kind of died in the Senate there, and so we're looking for another sponsor, to pick that back up. But things are being done, and I am hopeful and confident that Ohio is going to get there. That's just following the national trend. It's just a matter of Ohio just getting with it, doing what's right, and getting with everybody else on this issue. We're lagging behind. It's only a matter of time before the people in charge realize that we're lagging behind, and it's not a good place to be. Speaking to that trend, the number I mentioned, 28 states are not using JLWOP. That number was only 7 5 years ago. So it's quadrupled in just 5 years. So that's kind of where the hope comes from. I don't know if I'm too optimistic about it or not, but that's where the trend's going, and so hopefully Ohio gets with it. I mentioned the United States Supreme Court decisions that were heeding that brain science. Steve's going to talk about those. They kind of establish the guidelines and the rules for when and when not juvenile life without parole sentences can be imposed.
Okay, thank you. I'm Steve Hardwick, and I have several of my clients are serving juvenile life without parole or close to it. But I'm going to move back to where this all began, at least in modern history. That's with a young man named Christopher Simmons. Back in 2005, he was facing the death penalty for homicide he committed in Texas. That was he got the death penalty for. The U.S. Supreme Court in 2005 said, okay, you cannot, categorical bar, you cannot kill children for things that they did as children, no matter what. That's it's an absolute clear black line in the sand. They cannot kill children. Then moving on in 2010, we said, well, what can we do with that? Looking at the reasoning behind it, we looked at a case, we meaning the defense bar, not me personally. Terrence Graham, this was for, I believe, a burglary down in Florida. He got life without parole for it. It went up to the U.S. Supreme Court, and the U.S. Supreme Court, we were hoping at that point they would say no life without parole for kids, period. They didn't. What they said is no life without parole for kids who haven't killed. And they said a child who did not kill or intend to kill has twice diminished moral culpability, meaning they didn't do this and they didn't kill and they're still a child. One of the difficulties in understanding what this meant is they said no life without parole, but they also said kids needed a, quote, meaningful opportunity for release. Well, that raised a number of questions. First of all, when it said, going back here, a child who did not kill or intend to kill. Well, when they came to homicides, they did say, well, maybe you can give life without parole for a homicide, but you can't make it mandatory, because there are a whole bunch of states where if you got convicted of a certain level of homicide, you went to prison for life, period. You couldn't even argue about it. It was mandatory life without parole. They said, no, you can't do that. You have to at least give the kid a chance. And that was in a case, that was Evan Miller versus Alabama. Well, remember I said no life without parole, but then it also says meaningful opportunity for release. Well, then came another question. Well, we had a number of clients in Ohio. I had clients of, mine was Chaz Bunch here. Brandon Moore was his co-defendant. It was for, one was 15, one was 16 for as a rape in Youngstown. They didn't get life without parole, but the judge at sentencing gave them sentences that stacked well over 100 years and said, on the record, I want to make sure you never leave prison. Well, the Attorney General came back and said, well, that's not life without parole. That's 100 years. The U.S. Supreme Court never said anything about that. And for Chaz Bunch, and he's been my client since 2006, 2007. The good news for him is through a through a weird procedural mechanism, he actually is going to have a new sentencing hearing later this month. And Brandon got a new sentencing hearing last year. Unfortunately, he got 50 years. That's on appeal. That's still being challenged. But the good thing is, in a case called State versus Brandon Moore, and Brandon Moore's case went to the Ohio Supreme Court, not the U.S. Supreme Court, the Ohio Supreme Court. And a lot of this stuff it's important because when it happens in the state Supreme Court, they fleshed out some better rules than have been decided nationally. The Ohio Supreme Court said, no, keeping someone in prison at least until their 90s, we're going to say that's life without parole. You can't do that. They didn't tell us exactly what the cutoff was. They unfortunately looked at actuarial tables for when people might die and said he's clearly going to be dead then. There's some dispute over whether we should look at, well, just to make sure they have some chance to walk out the door as really old men, or what is a meaningful opportunity for life mean they have to be let out earlier, or at least get a shot to be left out. Remember, it's not a guaranteed release, it's just, if they've messed up in prison over and over again, under the U.S. Supreme Court case law, the parole board can keep them in there forever. The Ohio Supreme Court then came up with Eric Long is my client. He's out of Cincinnati. He was in a car. The prosecutors say he was one of the people who pulled the trigger. We say he wasn't, that's not what the evidence showed. We'll never know because that wasn't a question the jury asked. It was a shooting on the freeway from one car to another car. He had a sentencing hearing where the judge could have imposed something less than life without parole. But the judge never actually considered youth as a mitigating factor. So we went back to the language in Miller and said, no, it's not just that you can't, it's not mandatory means that you have to consider their youth. And the Ohio Supreme Court agreed. And they said, no, he gets a new sentencing hearing. And they sent it back. Unfortunately, the same judge gave life without parole again, and we're challenging that. I did his appeal, and we have a petition pending. We just filed an amended petition a month ago in the court, and we're hoping to get a hearing on it. At his resentencing hearing, he decided to hire his own lawyer, and that lawyer did almost no work for him. The court appointed a psychologist, and no one told him the psychologist was coming. He had family visits, so he basically told the psychologist after a little bit of time, go pound salt, I have family coming, and then the judge got really mad at him for losing his opportunity, supposedly, at a psychological examination. And I still tried to convince people that if you were, and he's now well into his 20s, but you have someone showing up you're in jail and asking you to talk about your deepest, darkest secrets, and you're not told about it in advance, you're probably not going to be all that cooperative. But the Ohio Supreme Court did say the court must say on the record, we have considered youth as a mitigating factor. That's a big deal in Ohio because I don't know if people talked about it earlier, but when you sentence people in Ohio, for the most part, judges don't have to give reasons. In fact, they often don't, because if they open their mouth and start explaining their sentences, that gives an appellate lawyer like me something to pick at. So they said, no, I'm just gonna keep my mouth shut, and the appeals courts will just presume I thought everything correctly. So that is a big deal, that the judge at least has to go on the record and say they did that. Here's something, that one of the more important cases, another more important case got the U.S. Supreme Court was, there's a guy called Henry Montgomery. He's still in prison in Louisiana, very old conviction, and and the U.S. Supreme Court said, yes, these people have been in prison forever, even though no matter how long they've been there, they deserve a shot at a new sentencing hearing, or at least to raise the argument. Going back to one issue we have been litigating, and its difficulty is, remember when I said kill or intend to kill? The Supreme Court wasn't very clear on that, and we're trying to. And there's some prosecutors have argued that even attempted murder counts as a life without parole because that's intended to kill. We're arguing that no, the state has to prove both intent to kill and that they killed. So one of the issues in Eric Long's case is was he one of the shooters or not? And if he's not, who has to prove that? Do I have to prove he's not the shooter, or does the state have to prove he is the shooter?
Can you tell me when, in a case of where somebody is strangled,
Yeah.
okay, as cause of death, and there are 4 people in prison all charged with that murder, how does that happen?
Well, that's because that's probably complicity, and that's the issue in Eric Long.
But they're all aggravated murder.
Yes, complicity to aggravated murder. And if you're guilty of complicity to aggravated murder, it's just the same as if you were guilty of aggravated murder itself, as if you did it yourself. And the way the law is supposed to be written is that you had to have the intent, you had to intend that the person die just like that other person did, even if you weren't the one who did it.
So it's like, okay, because there's this, my fiance's situation is somebody did this, and in one of his co-defendants' appeal, it says in there that person did put a belt around this other person's neck and kill them or whatever, but they're all aggravated murder, and they all have 20 to life or double life or
Yes,
another one.
yeah, and setting aside the juvenile life without parole issues, the way the law says it, if you're with a group of people and you all have the intent, you all have the same intent, you all intend for the same thing to happen. It doesn't matter which one of you did the strangling. You're all this equally guilty. Now they're supposed to prove that the other people actually intended the person to be strangled, and that can be an issue in some cases, whether they've been able to prove it. I don't like that part of the law, but that is the law. With juvenile life without parole issues, what we're trying to say is, okay, he can be guilty of aggravated murder even if he may be guilty of aggravated murder through complicity, but he had to actually be the one who pulled the trigger to be life without parole eligible. That is being litigated. By saying litigated, that's what we lawyers are arguing about. I can't give you an answer. One difficulty we have, and I think when we talk about remedies we've had in Ohio, is most states have some sort of remedy where even if you get a new court decision, you can go back. Ohio only has that for people who've got the death penalty. So we've had to make stuff up, make up remedies. Brandon Moore, the Ohio Supreme Court case, he and Chaz Bunch initially both what they filed, I'm not joking, to get their case back was a motion for an extension to file a motion for reconsideration. That was, and it's a weird oddball thing. Chaz Bunch actually only got back because back in 2001 or whenever, he filed his own petition that everyone ignored. So it was timely and it was sitting there, and we have this rule that says you can amend it as long as no one's responded to it. So like 15 years later, we filed an amended petition, and boom, that's what got it. But that's why we're talking about legislative remedies here, because these oddball litigation techniques are really hard to make work. So that's why we've been fighting in the legislature. That's why. Yeah.
What about prosecuting discretion?
No, that's a big, and that's one thing that actually has me concerned. Is if I remember right, there are only 2 or 3 people with kids with actually serving life without parole when Miller came out in Ohio. And something I'm concerned that it looks like judges may have gotten the idea. Wait a minute, Miller now says we can give life without parole if we think about it first. So, and what do we have, 6 or 8 now? Life without, people actually labeled life without
I,
I think it's, but
there's 11 total, but I don't know if that 11 includes the term of years
term of year.
or not, yeah.
But but one thing our office does do is if you get life without parole or the equivalent sentence, we treat it internally almost as if it's a death penalty case. We will,
It essentially is.
It is, because they will die in prison. So what we do is if they don't win, there's a kind of action, the petition that Chaz Bunch filed that requires lots of investigation where you can put new evidence into the record. You can call the lawyer ineffective. We do that for every kid who gets sentenced to life without parole or the equivalent. And if we can't do it, every once in a while, for instance, there's a kid who got life without parole and our office represents the co-defendant who got the death penalty. Well, we actually pay outside lawyers, give them contracts, because we can't represent our co-defendants, our clients' co-defendants. We pay outside lawyers to represent that person and give them free rein to decide what's best, what arguments they want to raise. If they want to blame our client, they can blame our office's client, because obviously when you have two people there, they want to blame each other. So that's one major step we've done. And I think you're going to talk some about the legislation.
Yeah, a little bit. So that kind of covers what our office does litigation-wise. We do have a working group. It's a kids in adult prison working group, of which Steve and I are both members. There's about 15 people who are in the group, and Heather in the back is a member of that group as well. And so I would say about half attorneys, right?
Yeah.
And so a number of us are litigating these issues. The functional equivalent of a life sentence, which is like term of years. So that's going back to Brandon Moore's case, Chaz Bunch. You know, what he got 112 years the first time around, 50 now.
I think it's more like, on his first appeal, he went from like 150 to 130.
Yeah.
Which, yeah.
And so that's becoming the issue, yeah. And so they sent it back saying, you know, this is a life sentence, you can't do that until
Actually, in his
from
case,
150
the first-
to 130.
Well, the first case it went back is the
With the straight
firearms
face.
specification. It's a weird technical issue on firearms.
So that's like the issue that's playing out in the courts right now is what constitutes a functional life sentence. You know, at what point is this cutoff? Yeah, you know, unfortunately, as it stands right now, the national consensus seems to be about 50 years. That's how it's shaping up, and that's not enough. You know, that is not satisfactory, especially when you're talking to kids 17. You know, at the time, and the aging that happens. You know, when you're down, it's a different type of aging. And so, you know, one, they need to consider that and trying to get them to. But two, getting back to legislation, that answer is not acceptable, 50 years. And so trying to get the legislature now to make that cutoff much, much, much sooner, specifically, we're asking for 15. A 15-year cap on all juveniles.
15 years to the parole board.
Yes, yeah, for an opportunity for parole. Ideally, it'd be 15 years, you know, total.
My fiance doesn't see the full board until 2037, it'll be his first time, 36 years.
It's too long.
Like the 17,
It's-
two months being 17, as
Go-
a conference.
You know, going back to the brain science that we were talking about earlier, there are social science studies as well, talking about, you know, the usefulness of punishment. You know, like they say that it's useful up to a point. And after that point, it becomes, you know, a point of diminishing returns. And it accomplishes the exact opposite of what these courts and judges were trying to do in the first place, both for that particular individual and for society as a whole. I think that needs to be considered as well. People need to, you know, start talking about that. But getting back to the legislation, given the discretion that courts have, that judges have, we know that they have, you know, far too much. We think that legislation-wise is the place that we're going to get more traction. One, you know, you're going back to that same judge, like in Brandon Moore's case, you go back to the same judge for the resentencing and put it right back in that judge's hands. He did get it.
He did recuse himself after being very angry about it. He did.
Yeah. So in his case, he eventually got a different judge, but more often than not, that's not going to happen. So even if we were to make some headway litigation-wise, arguing these cases in the courts of appeals, The remedy, like Steve mentioned, is to go back for a resentencing hearing. And that sentencing hearing is going to be in front of the same judge unless, like in Brandon's case, you show these circumstances showing bias. So for those reasons, the CAP working group, the OPD, has been focusing heavily on legislation, on getting laws passed. Like I mentioned at the beginning, there was a bill pending last session. Unfortunately, it died. And one of the sponsors, Rezabek, was appointed as a judge. So the bill lost the sponsor, and I think from there it kind of stalled out. That said, they were able to get another bill that's pending right now, and it should come up for a vote. You could kind of fill in the gaps, Steve, but in the fall is my understanding. When they come back in session, this bill should be voted on in the fall. So I have another handout as well for anybody
Is that
who's.
the 100?
What's
It has to be 100?
Yes. You know what? That was the first one.
Okay.
Yep.
That was the second.
Yeah. And I'm not sure, forgive me, not sure which number this is, but I can get that to you for sure. But here is kind of a script that our office also has a legislative liaison who kind of connects us, the OPD, to the legislature and kind of does the bidding, I guess, so that we have a representative who can chirp in these legislators' ears, about what's in the best interest for our clients and the community. So I do have a script here for you with information about the bill, contact information, who to call, and kind of what would be helpful to say for anybody who's interested and want it. If you want to get off the script, and tell them what you think, absolutely feel free, but we thought this might help.
We need
so
it
pass this
outdoors.
around too.
Absolutely.
I would say for this particular bill, in talking to our legislative liaison, to wait closer to September, October, when the bill comes back up for a vote, just because at that point, I think the input would be most impactful, because that's when it's going to be on their mind. That's when the bill is going to be, on their desk right in front of them, when the conversations are going to be happening in the State House. Unfortunately, if you call too soon, we don't know where the information goes if you're forced to leave a voicemail, but they will be back in office in session closer to that time.
Will this be retroactive to people who are already in there who were sentenced to life as juveniles?
Do you know?
It's the way it's understand. That's the way it's been written. They can always change it if they want to. But
It is retroactive?
that's I haven't checked the most recent one. I can't believe my office would support it if it worked, because there's no reason.
Our bill does too, it has that caveat in there.
And that's actually been some of the sticking point is sometimes individual cases can make legislators can find it difficult when there are individual cases that get special media attention. Well, this person's going to benefit from that, and that can cause that's why the legislators need some